How do courts determine if consent for a blood draw was truly voluntary?
The question comes down to whether it was knowing and intelligently given. As it applies to voluntary consent, the question becomes whether or not you are capable of giving consent. So if you're unconscious as a result of a car accident, for example, that cuts against your ability to give voluntary consent. If you're laying in an ambulance and you have fentanyl through an IV going into your system, medications can affect your ability to give voluntary consent. So there's a lot of factors specifically related, mainly in car accident cases, as to whether or not you can give voluntary consent. As it applies to implied consent, the question remains the same. Was it knowing and intelligently given? And so if an officer doesn't give you accurate information as to the consequences of giving blood, for example, an officer says that you will automatically lose your license or that you will lose your license immediately upon your refusal, those cut against your ability to give voluntary, knowing, and intelligent consent and can be an issue that we can address as far as whether those blood results are admissible, meaning whether they can be used against you in court. We potentially could suppress that, which ultimately could have a major factor in getting your case dismissed, a not guilty verdict, or negotiations as a way to try to get a reduction from the DUI charge.
What rights do drivers have when it comes to blood draws in Tennessee DUI cases?
Yeah, so as it relates to the blood draw is once you have been arrested and an officer decides they're going to ask you for a breath or a blood sample, typically in East Tennessee it's going to be a blood sample, is you actually have an absolute right to refuse it. Is when you get a Tennessee driver's license or you're driving on a Tennessee roadway, what officers refer to is the implied consent that you are going to give a chemical sample for testing, but you actually have an absolute right to refuse it. What becomes an issue is while you have that right to refuse it is an additional charge. Now, it's much more of a civil violation than it is a criminal charge, but it is typically handled at the same time of probable cause in your case. So what that entails is a potential loss of license, but it is denying the state's best evidence against you for the DUI.
Can my blood draw results be admissible if I did not consent?
Yes, your results from a blood draw may be admissible even if you did not consent to the blood draw. A blood draw is admissible so long as it was lawfully obtained. Under Tennessee law, absent consent, a blood draw may be obtained if the law enforcement establishes probable cause and obtains a valid search warrant. Law enforcement may also obtain a blood draw absent consent or a warrant if exigent circumstances exist that would risk the dissipation of alcohol or drugs in your blood. Now, even if a blood draw is taken without your consent, we may have arguments to suppress the blood draw. Depending on the facts, we may be able to argue that probable cause did not exist to obtain that warrant, or we may be able to argue that the exigent circumstances also did not exist. Even if a court finds that the blood draw results are admissible, we may also have arguments regarding the reliability of the blood. There are standard operating procedures that phlebotomists are trained to follow in DUI cases in order to ensure the reliability of the blood. If any of those procedures aren't properly followed, we may have an argument that even if the blood is admissible, it may not be reliable.
How did Tennessee's implied consent laws change in 2026?
Beginning January 1st, 2026, the Tennessee legislature made some pretty significant changes to the state's implied consent law. First, the legislature closed a loophole that prevented the state from pursuing implied consent violation charges against a driver who refuses a blood sample, but blood is later obtained via a search warrant or exigent circumstances or other lawful means. The law now specifically states that the state may pursue implied consent violation charges against a driver who refuses a blood test or other chemical test, but blood is later obtained via a search warrant or lawful means. Second, the legislature increased the driver's license revocation period for a driver who is found in violation of the state's implied consent law from 1 year to 1.5 years.
Is refusing a blood test in a DUI stop a good idea or a bad idea?
So it's a bit more complicated than that. So whenever an officer charges you with, and believes that they have probable cause to arrest you for a DUI, in almost every case, they're going to ask you for a chemical sample. Now, generally for East Tennessee, that's going to be blood. It can be breath, but almost every county at this point relies on a blood draw to determine what your blood alcohol or any toxins in your blood are. As far as consenting and saying yes to the blood draw, the issue with it is it's going to paint the most realistic picture of what it looked like at the time. So if you have reason to think that your blood is going to be over the legal limit, if you have concerns about any medications that you might have taken, is you're giving the picture closest to the driving of what your blood would have looked like. If you refuse, the officers still can get a blood sample from you. Because what they would do is they go to a magistrate or a judge and they swear out a search warrant, which is there. The officer can then take you to a hospital or take you to the county jail where a nurse would draw a chemical sample for testing. Now, the issue with refusal is, and especially with the new law changes from January 1st of this year, is that when you refuse a chemical sample, the penalties have increased. So it's gone from a mandatory 12-month suspension of your license if found to have violated it at a preponderance of the evidence hearing. It is now 18 months. Now, that is not an automatic loss of license from the time that you were arrested and charged and refused the sample. It doesn't work like that. It is generally the hearing is going to be at the same time that probable cause is determined, but in reality, they can be separate hearings. But by and large, whether there's a right or wrong answer of whether to refuse, really, you're the only one that knows. So if you're somebody who feels like you're sober and you feel like the officer is making an incorrect decision, it may benefit you to give a blood sample, because blood, while the best evidence for the state, can also be great evidence for the defense. It's a very fact-specific analysis.
How do we challenge blood results in a DUI case?
Two primary ways: admissibility and reliability. Admissibility comes down to filing motions to suppress the blood based on issues with the blood draw, based on issues with voluntary consent or implied consent, such as whether the officer got a signature on the form before requesting blood, whether or not there was probable cause to request the blood sample in the first place. So plenty of motions that could be filed as to whether the blood is admissible to be used against you in the first place. The second way comes down to reliability of that blood sample. In the state of Tennessee, there is DUI and then DUI per se. DUI per se, if a jury was to believe the number in and of itself, they can convict you even if you look great on the video and you do not have any bad driving and there's no reason to believe you're DUI other than the blood results. So then we have to look at issues with the reliability of that blood sample. Many ways we can do that. One such way, for example, that we can see on the body cam is when they draw your blood, they have to invert that tube 8 times to make sure the sodium fluoride, potassium oxalate is mixing in with the blood to preserve it over time between the time of the blood draw and the time of the testing weeks or months later. There's many issues with chain of custody. One of such can be whether or not it's in the fridge or whether or not the sample was on ice when it's driven from Knoxville to Nashville, for example. Because if it's not in the fridge, it's like having a sandwich on a kitchen table for hours and then eating it later. Most people would advise against that because bacteria grows on that sandwich. The same thing with a blood tube. Bacteria grows in that tube. It can become ethanol. It can make the blood sample significantly higher than the blood itself that was in the human body at the time of the draw. So many issues as to the admissibility and the reliability. And so it's important that every little issue is examined by a defense attorney and potentially an expert as well to address in court either through motions or to convince a jury as to the reliability of that sample and trying to get a not guilty verdict.